I'd like to welcome everyone to the National Lien and Bond webinar on how to avoid signing one-sided contracts. One-sided contracts are a big problem in the construction industry for many, many years. It used to be people would shake hands some time ago and work with each other. Recently, with all of the electronic discovery and all of the problems that have been going on in a litigious world, general contractors seem to have taken over the power from the top down in order to manage their projects the way they seem fit, which is basically put ironclad provisions over suppliers and subcontractors. So National Lien and Bond, as many of you may know, or mechanicslien.com is a organization that supports people's rights in a neutral way. We tend to represent more suppliers and subs than contractors, but we represent different people throughout the United States. And since 1985, we have, as you'll see today, a representative sample, one lawyer in every state that is very well vetted and experienced in the area of construction law. So I think this will be a very exciting program today. And before we start, I want to introduce the panel. So Jean Terry on my left is from Kentucky. She's a relatively new member, but she is going to tell us a story today, which I'll explain when we start. That'll be very exciting. Then Lamar Johnson is our legal assistant at my law firm, Emil Farb, Swan & Bain, as general counsel to National Lien and Bond. And then Brad Kaufman from Towson, Maryland is joining us. Yuri Litvak from California, New York, and Florida. Yuri has 3 offices. We have the pleasure of him joining us today. And then we have, of course, Bruce Kaufman on the right, who has been with National Lien and Bond, I don't know, 40-some years. And he's also the American Subcontractor Counsel in Baltimore and Maryland. So he'll be talking quite a bit on what are the killer clauses that you've got to look out for. And Yuri's going to be talking specifically about the insurance requirements and the problems that come up when people start making claims and ask you to indemnify them for a whole bunch of things, which Yuri will be talking about. So in order to begin, let me start with Jean. Jean, I'd like you to tell the story. I'm very impressed with what I heard. Now I want to see how you did it. There was this general contractor, we won't say boo, but a general contractor that worked for an owner, and the general contractor was smart enough for himself to put a clause together that he's not responsible with the owner for consequential damages. And then if the subcontractors on the job had a pass-through claim, they would benefit by the same clause. So subcontractors should be aware, and suppliers, that there are pass-through clauses that GCs make you sign. Here might be a good one that you would have been benefited from, and it would not have been a one-sided contract, it would have been in your favor, and apparently in Jean's general contractor client's favor. So Jean, tell us the story about what you did and how you helped your clients.
Yeah, so thank you, Hal. I really appreciate everyone taking the time to be here. As Hal said, I'm Jean Thierry. I'm a partner with Mannion Stigger in Louisville, Kentucky. Before rejoining Mannion Stigger, I was a partner with a national law firm in the #5 construction group in the country. While I was with the national law firm, I represented primarily structural steel fabricators. So really the experience of a sub getting beaten up is very, very near and dear to my heart. But I'm excited to be here today and kind of hopefully give you guys some tools that may help make the construction industry a little bit easier to swallow. So I'm going to share a screen here. 3 types of damages in construction cases. There's direct, which is the easiest one to understand. It's the cost to repair or complete. So if someone breaches the contract, it's the cost to repair the work or to finish the project, or if you're the contractor, it's what the owner has to pay you because you did repair and complete the project. Consequential is the main point of what I'm going to be speaking about today. So let me do that one last. And then liquidated damages are a negotiated way. So in the event that a contractor causes a delay, which we all know is rare, and that's usually the bad owner's problem there, the owner may suffer monetary damages. Rather than try to prove actual damages, the liquidated damages are a agreed upon amount that the owner will suffer due to the delay. It's typically a daily amount. You know, I've seen everything from $200 a day to $1,500 a day, but it's actually spelled out in the contract that this is the amount of liquidated damages. So as long as the LDs are reasonable prediction of damages and not a penalty, most courts will enforce them. Now, the LD provision is both a floor and a ceiling, meaning that there's a minimum amount that will be paid, but it also caps that amount. One instance is I was representing a very specialized utility product supplier in the expansion of a power plant. And that contract with my client had with the general contractor, it had a daily amount for liquidated damages, but once it hit $1 million, the GC could not recover any more for liquidated damages. So the GC actually claimed that they had hit the entire $1 million limit against my client for delays. So that's how it's the floor and the ceiling. And the owner cannot enforce a liquidated damages claim if the owner contributed to a delay. And in that case with the power plant, that's actually what I was able to show, is that the GC contributed to the delay for my client. And so we weren't liable for the liquidated damages. Now, speaking on what we're going to talk today, consequential damages. So these are damages that don't arise directly or immediately from the breach of the contract. So for the owner, that can mean lost profits. For the contractor, that can also mean lost profits. It can also mean the overhead at your home office. An interesting area too is that the more LEED certified projects and other green projects we're seeing people claim sort of green damages. You know, if your building was supposed to meet a specific energy level and it's higher than that, then you might have, an owner might try to go against the contractor for the higher energy costs, or if they lose out on tax benefits because it's not built in time and the LEED certifications aren't there. So those are just some examples of consequential damages and the other damages that you can see in construction cases. So speaking about consequential damages specifically, the parties can agree to mutually waive consequential damages. And what you see on this slide is the mutual waiver of consequential damages that's in the 2017 AIA A201. And the A201 is the general conditions that are incorporated by reference in the AIA documents. You can see something like this waiver in the AGC's consensus docs too. It's, I don't know, I don't necessarily want to say standard, but it comes up a fair amount. Now you'll see in these subsections 1 and 2 that it's kind of a listing of the types of damages that the parties are agreeing to waive, the types of consequential damages. But if you look at this very last sentence here, it says that really this isn't necessarily a mutual waiver, okay? Because the owner can still get liquidated damages through this last sentence. And the whole point of liquidated damages is to capture the owner's consequential damages, or if you're a sub, to capture the GC's consequential damages. Meanwhile, the lower tier contractor is left with no way to recover these types of damages that are in his or her contract and that they lose out when there's a delay. So what I'm going to talk to you about today, as Hal said, is a case that I had here in Kentucky where I represented a general contractor against an owner in an arbitration under the American Arbitration Association construction rules. Now, the owner had hired my client, a general contractor, to build an expansion to an existing daycare and preschool facility here in Kentucky. The owner and the GC used the AIA form documents. And in that contract, they separated the work into 2 phases. There was the design phase of the project and the construction of the project. My client performed the design work, but was ultimately not selected to construct the project. Unfortunately, my client was also not paid for his work. So we filed the demand for arbitration because that was the selected method of dispute resolution in the contract. We also filed a lien against the project. And as Hal will tell you, I am a big fan of filing a lien claim. Even if that's not ultimately what you have to recover on, it really lights a fire under reluctant owners and reluctant GCs to make sure that you're getting paid. And it just adds, it's just one more arrow in your quiver that you can use to recover your money. So lien claims, bond claims, those are all really, really helpful tools that you should always be using to the extent you can to really encourage payment and encourage a quick resolution. So In this dispute, the owner responded to our demand for arbitration, asserting a counterclaim for almost 3 times as much as my client was seeking in his arbitration. So I've snipped here the counterclaim damages summary that was filed by opposing counsel, by the owner. And the good thing here was by this point she had reduced her claim, because this was filed just a week or two before the actual arbitration hearing. But as you can see, even though her claim has now been reduced, it's made up almost entirely of consequential damages. She's got rent here, added interest on her loan, lost income, depreciation, all of these things that are typically classified as consequential damages. So when I looked at the contract in this case, it was again an AIA form contract. And it's an earlier version than the 2017 that I showed a few slides ago. But so this contract specifically has a consequential damages provision. So at the arbitration hearing, when I cross-examined the owner, what I did was I blew up into a giant hard copy this portion of the contract, because also at one point during the cross-examination, the owner claimed that she was unable to read tiny print. So luckily the arbitration was at my office, so I blew it up to this gigantic poster size and asked her to get out her glasses and read it to me. And then after she read it, and after it says here that the design builder, my client, and the owner waived claims against each other for consequential damages, I asked her how she could possibly be entitled to any of the damages she's claiming when she agreed to this damage, when she agreed to this provision. I mean, it specifically says rental expenses, loss of use, income, profit, financing, pretty much the exact listing that was in her damages summary. Now, of course, her attorney went through the roof when I did this, but I had done the homework on my front end there, and I had specifically selected a great arbitrator who knows construction, and he ultimately enforced the plain terms of the contract, which here awarded the owner nothing. So that's another little tip with your contracts is you want to make sure that to the extent you're using arbitration, you're really using that provision. I'll put into my contracts of I want somebody with at least 7 years of construction law experience. And I'll put things about what we can get in discovery and what we can't, just to try to keep the costs down. But it really behooves you to do your homework with arbitration and really make that method of dispute resolution work for you. Because I don't know if an attorney who wasn't familiar with the AAA documents, if I had gotten that person as an arbitrator, if they would have been as comfortable with enforcing this. And then the cherry on top about this case was that thanks to the provisions that you see on this slide, my client was actually able to get his overhead and profit because he was terminated through no fault of his own. The owner had no basis for terminating him. And so thanks to good contract drafting where he says cost plus overhead and profit, that's what we were able to recover. So that's it. That's my 15.
Okay, great. All right. Okay, so thank you very much, Jane. That was like great, and it sets the stage, I think, for Bruce now to come up and talk about the killer clauses and how we're going to be able to fight back and get the result that Jane got because she had a really good clause in her favor. Jane, by the way, how did you get that clause? How did your client get that clause in there? I mean, you know.
So he's really, really good at listening to me. He's not 100%. So generally my favorite is that when I actually can get a client to let us completely write their contract documents and I go in and do in-house training so that my client and all their project managers and everybody knows, hey, these are the landmines I put in here. This is the good stuff that will help you. This is how we use it. But he also was really good he was very committed to using AIA forms because that's what his owners liked, is they liked the AIA forms. But he listened to me on the extent of just because it's an AIA form doesn't mean that you can take some liberties with the drafting. And you can make sure to include things like waiver of consequential damages. You can make sure to include things like you get your overhead and profit. You can be specific about who is your arbitrator. So it's just a good client that really took what I said to heart.
That's wonderful. And I like how you said when you and I first met, I asked you about mechanic liens. And you remember what you told me?
They're a jam.
Yeah. You got that? I don't know. Maybe I don't know if everybody's from the South. So can you repeat what you said? What did you say?
Sorry. Mechanics liens are my jam. It's something that it's my favorite part of what I do. And actually the first day I talked to Hal, I had two going out that day. It is something you'll see on the internet. There's a lot of programs that try to say that they can do a lien for you and do it quickly. And ultimately it's a relatively inexpensive tool that provides you a lot of security and a lot of peace of mind, but it is incredibly technical and detail oriented, and it varies state by state.
Right. As you know, I went through 18 law firms to find you. Okay.
Yes.
And thank God we went through. Lamar was helping me. He can tell you the story too. It was like a day from, the mechanical liens are our jam too, but finding the right local counsel, because I was retired, before we didn't have anything the last couple of months in Louisiana, in Kentucky. So it was great to have you there. But can you tell us for 1 minute, what kind of liens are available to suppliers in, for example, Kentucky? Because I did read the statute. I was looking for the 18 lawyers, and I was like flabbergasted. Okay. And thank God, and I'm pretty smart on this stuff, how well you explain that. So what kind of rights do people have in Kentucky?
So Kentucky and Indiana, you can file liens on residential projects. You can file liens on commercial projects. Both states do have a unique recovery option for public projects. So those are projects like state highways, public schools, state universities. In Kentucky, for instance, we have a very weird quirk about the lien has to be what's called attested by the county clerk. And it's a weird, funky process. And essentially it just involves, you really have to have a good relationship with each county's county clerk to get it done correctly. We also have the Kentucky Fairness and Construction Statute, which helps for recovery of attorney's fees. And it helps block the enforcement of kind of killer clauses, if you will, about giving up your lien rights and what happens when an owner won't pay and can increase your interest rates. And then we have, there's always payment bond claims, which generally, if it's a public project, there's going to be a payment bond. So it behooves you again to look for it, especially Corps of Engineer projects. It's very easy to get the payment bonds, and that's pretty much a universal thing, that another tool that you can use to help recover.
That's great. It just for your information and for the other panelists in the audience here today, the lien on public funds that Gene did for us was on an elementary school, and you mentioned something. State highways or municipal. In the state of Maine, after you and I were working, we are now involved in a case, and I noticed that they had a right of lien on funds in Maine, but it was limited only to municipal projects, not state projects. However,
interesting.
Yeah, it was interesting because I'm in my state, which is emulating your state, it's a lien on public funds for state and local. But here it was only for local, not for state. However, when we negotiated with the subcontractor, who probably didn't know better, we were a supplier to a sub, to a GC, we said, we're leaning the funds. And that bothered him. So we kept saying that. Hopefully he wouldn't remember, okay, you can't have a lien on funds yet, just a bond claim. So just because you don't have something doesn't mean you can't ask for it, but you got to be a little bit aware of which is legitimate or not. All right, so thank you very much. Great story. Your client's very lucky. You were able to prevail, and you're a great counsel. Right now, Bruce, it's your turn to talk about what are the killer clauses and how do you recommend to our audience and to your clients how to negotiate them to get the same kind of result on other provisions that Jean got for her client.
First of all, thank you, Hal, for the opportunity. I think the most important aspect of protecting yourself as a subcontractor supplier is the attitude. And a lot of times, if you'll see the screen, you'll see a picture of Rodney Dangerfield. It says no respect, because a lot of times subcontractors just don't get the respect that they deserve. And unless you have the attitude to say, listen, I do quality work, I do good work, and I want to get paid for my work, you're never going to get anywhere in the negotiation process. So you got to expect more, and if you expect more, you'll get more. A lot of times, as everyone's probably on the panel's experience, general contractors will say, well, we don't negotiate our contracts. Well, my response to that is simply this. If it ain't the 10 commandments, it could be negotiated. And that's the mentality that my clients have. Sometimes I negotiated over a 30, 40-year period, probably 3 or 4 contracts a week. So I've negotiated a lot of contracts. You don't always get everything you want, but if you don't try, you get nothing. And ultimately, it's the client's decision how much they want to push for. Now, let me say this to you, which is very important. A lot of times clients will say, well, if I don't go ahead and do this job, I'm not going to get the work. I need the work. Well, if you get a job with a bad contract, it could put you out of business. We had a situation, excuse me, many years ago with a gentleman who had a bad experience on a job. He came to me, I got him out of it. And then he said, Bruce, I'm not going to do any more work unless you look at the contracts. Next job, ironically, comes to me, a company called Walsh Construction or something. It was a horrible contract. We went ahead, we changed it. These people would make one change to the contract. So what's that tell you? If they're going to be unreasonable now, they're going to be certainly unreasonable when they get on the job. My client said to me, Bruce, I'm not going to do the job. Literally a year later, this gentleman, Mark, calls me back and he says, hey, Bruce, I just want to say, how you doing? You know, what's going on? So I want to thank you. So he said, what happened? I said, why? He said, because the gentleman who did that job, these companies put him out of business. So I have one less competitor. So the most important thing you have to remember is if you don't want respect, then you know what? You're going to get sooner or later, you're better off. In my case, I'm a football player, old football player. Go to Vegas, put your number down. Mine was 22 and roll the dice because that ultimately you're going to get hurt and it could ultimately put you out of business. So the mentality is you got to negotiate your contracts. Now, we don't have a tremendous amount of time, so we can't go over all the provisions, but I do want to go over some of the more critical ones. Now, ultimately, the general contractor wants to shift all the risk to the subcontractor and the supplier. Okay, that's their goal. And you got to prevent that. And the way you prevent that, again, is through the negotiation of the contract. They want you to be responsible for the flow down liability, which means anything that the general contractor is responsible for with the owner, they want you to be responsible. Well, most of the times, you don't even see the prime contract. And even if you do, you cannot be subject to all the terms and the provisions of the general contract. What you want to do, and what you're only asking for, is a fair and reasonable subcontract. Now, a lot of times in negotiating a contract, everybody says, well, what's fair, it depends on what side of the fence you're sitting on. But these contracts to the general contractors are so egregious that we all know that they must be negotiated to protect yourself. And that's what you do. And sometimes, guys, it's a problem. It takes time, it takes effort, it's frustrating. But my clients have backbone, the majority of them. In fact, one of my clients recently, a mechanical contractor, I negotiated a contract for him. And he said, man, you got a lot of changes. I said, yeah, but George, there's 6 or 7 changes, we didn't get. He said, Bruce, go back and take another shot at it. So we did. And ultimately, we got 4 out of the 7. So again, you better spend the time now. What's that expression? You better pay me now or pay me later. Well, the pay me later could be a whole lot worse than the pay me now. Okay. Let's talk about some of the issues, scope of work. And a lot of these, not a lot, I'd say most of these subcontracts, you're going to see language that's going to say you're responsible for all things necessary to complete the job. You're responsible to do the work in accordance with the intended purpose. You're responsible to do everything that's necessary to complete the job. You can't agree to that. You have to limit your work to the plans and specifications. That's your roadmap. And let me tell you something. If you are a subcontractor and you do the work in accordance with the plans and specifications, you do the work timely, you do it properly, then you're entitled to be paid. And any general contractor should be more than happy if somebody accomplishes that as your subcontractor. So what we do in our contracts, we limit the prime contract, when we're talking about the scope of work, only that we've done the work per the plans and specifications. And we generally get that with most of our clients. Because we're not going to tell somebody that we're going to do work when we have no idea what the prime contract says, and we're not going to be doing work when it comes down to a situation when it goes far beyond what we contemplated as our scope of work. And that's what we try to accomplish. And for the most part, we always get that, because that is one of the lines in the sand that my clients will not cross. We are not going to be doing something that we don't know what our responsibilities are. And when you talk about the scope of work, you also may want to be very careful about a provision in these contracts that simply says that you're responsible for the accuracy of the contract documents. First of all, that is a non-starter. If you agree to that, it's contrary to the existing law. There's a Supreme Court case that says you as a subcontractor are not responsible for the accuracy of the plans and specifications unless you agree to it. So you can't agree to it. Why? Only common sense. You're not the architect. You're not the engineer. You don't know all the you don't know all the laws and regulations. That's the responsibility of the engineer or the architect. So we always limit that. We cross that out, and the negotiation that I have with my general contractors, I'll say, Tom, Harry, whatever, look, to the extent that we have actual knowledge that we know that there's something wrong with the plans and specifications, we'll tell you. But we're not going to be responsible that if there's something wrong with them and we don't know about it, we're not going to be responsible. And they'll come back and say, which I had last week, they'll say, yeah, but if you have constructive knowledge, if you know it's something you should have reasonably known, no, that's going to end up in a lawsuit. We fight hard for that, and we will not bend on that provision. And also, when you see in these contracts, and they're in all these contracts, you're responsible for the laws, the regulations, the codes, et cetera, et cetera. Again, you're not an architect, you're not an engineer, and you're not a lawyer. You have to add additional language. And that language is, we will be responsible to the extent it's consistent with the plans and specifications. That's a very important provision, and it can save you a lot of heartache if you ignore that. All right. Again, the dangers of the flow down provision, they want you to be responsible for everything. They want you to incorporate their lien waivers, maybe no delay damages, liquidated damages. Another important point in this contracts is they'll say, if you have a claim against us, you've got to give us enough time for us to give notice to the owner. Well, many, many times you don't even know what that notice provision is in the real world. So one, you have to put the amount of time that you have to give them, whether it's 5 business days, 7 business days. You have to specifically put that language in there that you're going to be able to give them the required notice. Otherwise, and trust me, it's happened to me many times, more than I'd ever want it to happen. The general contractor comes back and says, hey, listen, you didn't give us the proper notice. You've waived your claim. That's like taking a gun and shooting yourself in the head. So you got to protect yourself. And you got to know what the provisions of the general contract are. If you're going to be subject to those provisions, you got to know what they are. You got to know what the liquidated damages are. And as our prior speaker stated elegantly, under no circumstances should you ever agree to consequential damages. That, again, is the major provision that we draw the line on. We've had $1 million contracts with an opportunity to do much more work, one of my clients, and we fought over consequential damages. And ultimately, we said, we're not doing the work. And my guy has a strong backbone, this particular concrete company I represented for 35 years. And we walked away. They came back to us. Why did they come back to us? Does anybody have an idea? I'll tell you why. They got somebody else to do the job. And they screwed it up so bad, they called us up and say, hey, listen, will you take the job over? We said, yeah, we'll take it over, but now it's going to be on our terms. If you have to compromise, which I would suggest you don't do, if you have to compromise, what you want to do is simply say that the consequential damages will be limited to the insurance, our insurance coverage. To the extent we have insurance coverage, well, which most cases you don't, but if you do, we will consider consequential damages. But that is the last thing I would do. But again, that's off the table. That's the thing that puts you out of business. Okay. All right, let's talk about the payment terms. How crazy is this? You get paid only if we get paid. So years ago, it used to be, you have to wait a reasonable period of time, subcontractor, until we get paid. But that didn't take the general contractor off the hook. But now, because subcontractors have become such, I hate to use the terminology, abused spouses in a sense, that they agree to anything, including we get paid only if you get paid. Now, think about this for a second, how crazy this is. You go into Giant or Wegman or wherever you'll go shopping, and you walk out of that place. You're going to get stopped by security, and you tell them, hey, listen, I'm going to pay you as soon as my client pays me. You're going to end up in two places. In Maryland, you're going to end up at Shepherd Pratt, or certainly in any state, you're going to end up in jail. All right, now a lot of people are going to say, yeah, but how do you get around that? I mean, we're in the real world now. We are where we are. And I would say to you, if you're going to agree to something like that, then there's a few things you have to have in your contracts. I would never agree to it, but if you're going to agree to it, first of all, you have to say to Joe or Harry, whoever you're talking to, hey, listen, are you telling me, Harry, that if you're the guy at fault and the owner doesn't pay you, then I don't get paid? I mean, that doesn't sound fair to me, Harry. Oh, no, we're not saying that. I say, okay, well, then we have to clarify that if you don't get paid because it's something you do, and by the way, we have to include your subcontractors, then you got to pay us. And then the second thing you want to say is that, listen, in the real world, if I'm not getting paid, I can't pour concrete. So we have to have a drop dead date of, if I'm not paid within 45 days after I perform my work, okay, then I have to be able to stop my work. I can't continue to do work. And they'll say, well, 45 days. And then you say, wait a second, Harry, I'm getting nervous here. I'm getting real nervous. Are you telling me that you have a problem with your owner, that you're not going to get paid at least within the time frame of your requisition orders? And they say, oh, no, we got a good owner. We got a good owner. I said, okay, then fine. We got to have 45 days. I just can't continue to do work if I'm not getting paid. And generally, I mean, I would tell you, if I can't get A and I can't get B, i.e. A being you get paid within 45 days after you submit your requisition, or 7 days after the owner pays the general contractor, I got to get C. I got to get that you got to stop your work. And then let me tell you something. We had this last year where we had that in our contract, and we were dealing with a relatively strong general contractor, and they weren't paying us. And I made a phone call. I said, listen, we got to get our paid. I mean, this is dragging on, and we want to be nice guys. It was 45 days. Now it's almost 55 days. And I said, we're stopping our work. And guess what? My client had wired into his account over $257,000 because they could not afford for us to stop our work. So it's a good hammer to use, but it's critical because at some point you've got to minimize your risk. Okay, you've got to minimize your risk. And if you can't get paid, you can't do the work. Okay. Let's talk about final payment. Final payment, your retention essentially is your profit, right? And if you have to wait for 2 years to get your money, then it's a real problem for you. So what I suggest when we talk about retention, first of all, you talk to guy, you say, look, we're one of the first ones in. If that's the case, you got to talk to the owner. We got to get paid our retention at least 90 days after we complete our work. So if you have to negotiate, you make it 120 days. You have to negotiate more. You have to have a drop dead date, even if it's 180 days, but you have to have a drop dead date. You tell them, look, our bank requires a drop dead date for our retention. What do they say? Oh man, we're not a bank. We can't do that. We can't fund that. Then can you talk to the owner? And they said, we talked to the owner, we can't do it. Then what happens? You're going to wait 2 years? Okay, you're not going to wait 2 years. So what you have to do is say, okay, listen, this is what we got to do. I got to put a provision in this agreement, which actually protects you too, general contractor, that says that if we don't get paid our retention within 90 days after we do our work, that we have a right to file what I say, a petition to establish an enforced mechanics lien, or I usually try to put 75 days, or to be able to file a payment bond claim. When you have that in there, then when that time comes up and you go ahead and you file a petition to establish a mechanics lien, what happens? The owner freaks out. They say, wait a second, we can't have a lien on our job. Why? I can't get paid from the lender the money. So then what happens? We generally get our money. We generally get our retention. Okay, now also remember that you never want to be in a situation where you are having your more retention held from you than the owner is having with the general contractor. So therefore, you want to make sure that if they're taking 5%, you get 5%. If the law requires 5%, then that's all that's being taken from you. All right, let's go now to site, because we've got to move a little quicker, I see. Let's go to site investigation. This is an absolute, you talk about killer provisions, this is a killer provision. Because when you go on a site and they want you to be responsible to independently, whether it's a Whiting Turner contract or many other Turner contract, many contracts, everyone I see, you have to independently make sure that the site is suitable for your work. No. What you agree to is, listen, I understand, Harry, general contractor, that, I want to make sure it's only fair that I don't come back later and say that it wasn't good access to the site, that, I couldn't get my trucks in. But I'm not going to guarantee an investigation. I'm not doing an investigation of the underground of the conditions of the site. What I will do is I will agree that from a visual inspection, I've examined the site. So there is an access issue. It's on me, but not otherwise. And I always get that. And I say always get that provision because it's reasonable and they understand it. And by the way, as an aside, when I negotiate these contracts, you develop a relationship with the general contractor. And these guys, these general contractors, they're no slouches. They are very, very, very prepared and expert in what they do. They have their contract division. So when you're not negotiating with another attorney, you're negotiating with a guy who does this every day. And you develop a relationship. And at the end of the day, when I negotiate these contracts on many occasions, these people have said to me, Bruce, I got to tell you, now we're done this thing, I never would agree to this contract. Now, what does that tell you? I would never agree to what they're asking you to agree to. So you remember, don't be Rodney Dangerfield. Get the respect that you deserve. Negotiate your contracts because it's going to ultimately save you a lot of heartache and a whole lot more expense than if you get into a litigation situation. Okay, now let's talk about this concept of delays. First of all, you never agree that you waive delay claims. I mean, that could ultimately also put you out of business. Okay, you've got to be paid for delays if you are delayed. Now, sometimes you got to compromise and you say, okay, listen, if it's an owner delay, then okay, I'll only agree to get paid whatever you get paid. But all these contracts say that if we don't get paid for delays, you don't get paid. No, it makes no sense. It makes no sense. If the general contractor is the one who caused a delay, then why should you not get paid? Why should you go out of business or lose money on a job because a general contractor screws up and you can't agree to it. The next thing you got to be careful about is time is of the essence. Time is the essence means that if it's supposed to be done on September 30th, it's got to be done on that date, not October 1st, but September 30th. That's a legal terminology. It's a legal meaning. So you got to put what I put in my contracts, and I've been doing this for 25 years, and we've added, obviously, because of the pandemic. We say, look, we're not liable for delays caused beyond our control. We're not liable for delays caused by the owner of the contractor, other subcontractors, unanticipated weather conditions, epidemics, acts of God, vandalism. I even throw in now terrorism. That's a provision that is reasonable. And generally, general contractors don't complain about it. I rarely have anybody complain to that provision because you say, listen, I just want to be fundamentally fair here. How can I agree and how can you ask me to agree to be liable for damages that I can't control? That's your fault or someone else's fault. And bottom line is we get that change, and that's something we need. All right, let's get on to a few more and then we'll wrap it up. Okay, and I want to talk about this concept of, I know someone's going to be talking about insurance, but I want to talk about this concept of indemnification. Now, indemnification, the general contractor wants you to assume all responsibility for anything that can happen under the sun arising from your work. So that means no matter what happens, you're responsible. And you'll see in these contracts, to the extent permitted by law, you're responsible. We say, time out, not happening, not under my watch. We will agree to be responsible to the extent of our breach of contract, to the extent of our negligence, to the extent of our intentional misconduct, consistent with the AIA language. And I'll say to Harry, Harry, wait a second. Let's be fundamentally fair here. If you're 99% negligent and we're 1% negligent, are you telling me I got to indemnify you for your own negligence? And that's where my clients, even the guys whose backbone is not as strong as some of my other clients, they'll say, hey, look, we're not agreeing to that. That's insane. We'll move on to a couple final comments and we'll be, I want to get done a couple more things. And one is that this one concept that you cannot agree or always in tune to. You cannot agree to protect your work until the job's completed. A million things can happen to your work. It could be damaged by another contractor. It could be a casualty. It could be anything. You have to put a provision in your contract. Yes, we'll protect our work to the extent that we cause the damage. Or if you're, for example, a company does carpentry work and you have to put some kind of foam over your work, fine, consistent with industry standards. But you cannot have a carte blanche provision, which is in every subcontract, that you are going to protect your work for anything that can happen. Okay. And finally, I want to go over one or two other little points and I'll wrap it up.
Hey, Bruce, here's one good question that I think maybe you can answer. From Anna Sanchez. She wants to know, under force majeure, does that cover epidemic and pandemic, situations? I mean, we're all going through material shortage, supplies today, price increases. I mean, it's like unheard of. So
Okay,
what do you think?
That's a great question. And let me say this to you, and I didn't have time to put this in my presentation. I do have, and anybody can email me, I'll give it to you or go through Hal. I do have provisions for supply disruption provisions and for price escalation provisions. But the question's an excellent question. And the answer, I did an article on this when the pandemic first started. A lot of it depends on what your contract says. And there's different types of contracts, whether it's an AIA, whether it's a consensus document. So it all depends on your contract. And I would respond to that question by saying, if there's any ambiguity at all, you got to clarify it in the force majeure provision. So I would tell you that mere fact having the force majeure provision, it doesn't necessarily guarantee you the protection. All right, on the schedule, I want to just tell you this, and this is only from years of experience and problems we've had. You got to make sure that you have a schedule attached to your contract, because if you don't have a schedule, you're just going to get screwed. Okay, you're going to get screwed, no question about it. They're going to tell you you have to accelerate your work. You're going to have to spend all this money, and you're never going to get where you need to get. And if you see in these contracts, it says, they can decide the sequence of your work. They'll agree to that. It's got to minimum be reasonable, because otherwise, like my Caisson guy had recently, you'll be a ping pong ball. They'll have you go all over the place. They're going to screw up your means and methods. It's going to cost you a ton of money. And the last thing on this issue real quickly, I've come up with a provision, which I get in my contracts almost all the time. I would say all the time. And I say to my general contractors, listen, if you change the schedule and we incur additional expense, all I want to be paid for my actual verified costs that I incur. In other words, if I have to pay Sam, my employee, $1 extra, that's all I'm looking for. I'm not looking for Eichler. I'm not looking for anything else. And I'm being even very fair. I'm saying verified, because verified means I got to show you the additional costs. So that's a very important provision, because when they want you to accelerate the work, you want to make sure that at least you're getting your out-of-pocket expenses paid for. Okay, so a couple other provisions, but at the end of the day, if we don't have any more time, we'll just simply say one point I want to make sure that if you have any contract, you need to have a provision that allows you, if you're in default, the opportunity to cure or diligently commence to cure the default. I've won cases on this because the general contractor has either terminated us without that opportunity, or in one case, the attorney said, listen, I was afraid to terminate you because I was afraid the court was going to say I didn't give you the opportunity to diligently commence to cure the default. Finally, I never agreed to termination for convenience. If the owner terminates a general contractor, you could terminate us. You got to pay us the contract value of the work, not the reasonable value. That's too ambiguous. And you got to pay us our reasonable closeout costs. But if I'm taking a job and I'm not going to take another job, I don't want somebody unilaterally just terminating us. We've had situations where we've done the hardest part of the job, and then Caisson company represented, they terminate us. They got somebody to do the easier part and made a lot more money. So that's all at this point, I guess, with the time constraints. But I would just like to say at the end, please review your contracts, because at the end of the day, it's going to cost you a lot more if you don't. And I would tell you one other provision. I gave you some sample provisions, which you can look at your leisure if you have them. But the other thing is, you want to make sure that when you submit your proposal to a general contractor, you have a provision in there that says that the subcontract is subject to my lawyer's review and approval and negotiation. You don't want to be in a situation where they come back and say, well, it was part of the plans. Part of the bid documents. You have to sign this without any changes at all. That's a very important provision, and you need to put that in your proposals when you submit it for a job. So that's all I have to say. And any questions, I'm happy to answer them.
Bruce, thank you. I want to talk to you a little bit on termination for convenience for a second. You say you don't like it. Under the government law, particularly federal government, termination for convenience is like a fact that is incorporated into every contract. And one of the things I wanted to mention, besides having contract provisions that are express, there are contract provisions that are implied by law. And for example, if you have such as like prevailing wages, and you're working on a federal job or sometimes commercial job, but particularly government jobs, these laws are implied by these requirements are implied by law. In fact, in your neck of the woods, the District of Columbia, the Attorney General there is very strongly enforcing employment labor laws on subcontractors. And if you hire as a general contractor or sub and don't pay the prevailing wages that are required under the DC amounts, then that general contractor himself is vicariously liable to the employees of the subcontractor. And so you've got to be careful, even with flow down provisions, the GC is liable for the sub, and the sub could be liable for a sub-sub. Many subcontractors many of you as subcontractors may or may not be structuring your agreements, such as you're hiring a labor sub to do your work and you're doing the management, running the job and doing the project responsibilities and scheduling and bringing the materials in. And then you sub out part or all of your job, we've seen more recently, to labor subcontractors. Well, they have to be paying prevailing wages, because they don't, then you could be liable. And the same thing with termination for convenience clause. If that's not in a contract that's issued or it's forgotten about, by law, it's required. And I'm dealing with one right now in Afghanistan, and many of you know that we're working there with the U.S. Corps of Army Engineers for some subcontractors for many, many years. And now we're stuck with the things that are going on. So, of course, there are no more construction jobs going on because the United States isn't there anymore. So they suspended the work. Then they're asking for descoping, requesting mods for the subs to sign, and so on and so forth. So when you do termination for convenience, it's a court, whether you like it or I like it. In the federal public sector, it's not something that you have a choice about. In the private sector, more so, that's something you do have some more, flexibility with.
Yeah,
I just want to mention that.
I would just say to you, obviously, on a government job, if it's a termination for convenience is required, then obviously it's required. I'm talking about on jobs where you had that flexibility. I will say in Maryland, particularly, you can, just as you said, and I'm familiar with the DC situation, you can be responsible for a sub not paying. And that's why it's very important, which we couldn't get in everything, about making sure you have strong lien releases with your subs, if you have a situation like that, to put in there that they have paid all of their employees, so that at best you have an opportunity to go back to them under the lien release. But also verification is also key as well.
Yeah, and this will kind of lead to Yuri's part of the program, which we're coming up right now, that you talked a little bit about before, is that you would be as a GC or as a sub, hiring a sub or a sub as a GC, there would be an indemnification provision where if you did not make the payments, then you would be indemnified the party upstream from you, is really what it comes down to. So liabilities, now Yuri's going to be talking, and I'll let him present his program, but it's a perfect time for that subject, because having downstream liabilities and responsibilities when certain things happen is very important. And talking about how to have insurance protect you and how the insurance mechanics work is something that many of you may not be aware of. And I can tell you from my experiences, we should listen to what Yuri has to say, because if you do it correctly, it will save your company, it will save your cost, and it'll put you in a good position. And if you write the kind of provisions as Bruce was talking about, which we'll get some more sample provisions that will circulate after the program, probably early next week, I'll be talking to you a little bit more about how we're going to do that after the program too. But Yuri, let's get into your part of the program and talk about how subcontractors and GCs need to worry about insurance risks and how they manage that problem.
Thanks, Hal. Just by way of background, I spent many years working in insurance, first for a big law firm in New York called Skadden Arps, and then I worked in-house for an insurance company in New York. After that, I was general counsel for a developer, so I've actually seen some of these issues that I'm going to be talking about arise both on the subcontractor side, the owner side, as well as the general side. It's probably when I say it, I mean insurance, and the interplay between insurance and indemnification is probably the most overlooked issue when it comes to these contracts. I think most of you are generally familiar with the concept of indemnification. You know that it's in there, you know that it's a fact of life. You know that there's some correlation between indemnification and insurance because the contract talks about those things. But in reality, they are essentially inseparable or inseparably intertwined. And you have to analyze them together. If you don't, it can be sort of a bigger nightmare for you and potentially a life ender for you, worse than any of these other killer provisions that Bruce talked about earlier. The issue typically arises when an owner sues a general, defect case or what have you, and the general in turn brings in the sub. Included in those claims is a claim for indemnification. And the indemnification claim is typically tied to a contractual provision that says that the subcontractor is obligated to indemnify the contractor. And for what? We'll talk about in a minute, because there are generally three different types of indemnification provisions. And then the sub says, great, well, here's a certificate of insurance that I provided early on. So wonderful. The contractor must have coverage under my policy as an additional insured because I provided the contractor with a certificate of insurance. Wrong. A certificate of insurance is not what does it, and we'll talk about that in a minute. So whenever I represent subs, this is the thing that I lose sleep over more than anything else. Are the indemnification provisions properly worded, and did we properly secure that contractually required additional insured status for the contractor? And then has the claim properly been tendered, which is submitted to the insurer, such that the insurer is going to pick up the defense of the claim? And when I say defense, it's as important, but in many ways it's even more important than the actual indemnification, because the defense costs, as many of you know, in these cases are potentially so high and so expensive that in and of themselves they can be killers. So let's just talk briefly, backing all the way up, about what an indemnity agreement is. So an indemnity agreement in a construction contract is a promise by which one party, for purposes of our discussion, the sub, agrees to defend, indemnify, and hold harmless the other party, which, again, for purposes of our discussion, is the contractor, for acts or omissions related to the project. There are generally three, or historically, I should say, and I'll explain why in a moment, three forms of indemnification agreements. This is the first is the broad form, type 1, which includes the sole negligence of the contractor. They sometimes try to slide them in, but as we'll discuss in a moment, many, or actually most states, have now enacted these anti-indemnity statutes, which severely restrict the enforceability of those types of provisions. And then the second type, type 2, the moderate form, which includes all negligence except for the sole negligence of the contractor, which is still pretty bad. And Bruce alluded to that earlier, his example of the 99-1 allocation of fault. And then type 3 is the narrow form, which includes only the negligence of the sub. And most states have adopted statutes that determine which of these types of indemnity agreements are enforceable. And you know, we try to keep up with this by way of survey, national survey. And on the last survey we conducted, the only states that do not have a statute that limits the enforceability of indemnification provisions in construction contracts, or have a provision that's very limited, are Alabama, Maine, Nevada, North Dakota, Pennsylvania, Vermont, Wisconsin, and Wyoming. So that's roughly 8 states. And even in those 8, many of the courts, again, statute versus court decision, many of the courts have narrowly interpreted provisions that provide, or that provide for indemnity of a contractor for its own negligence. The rest of the states have either broad or moderate prohibitions on these types of indemnity agreements. So it's important for this analysis to be done on a state-by-state basis. So I know that some of you sort of are licensed in various states, especially states that consist of a metropolitan area that covers more than one state, and that can actually vary. So it's important that when you're entering into these agreements that you study the indemnification language that's being proposed. Do not take it as a given. It can, on its face, depending on which state's law should apply, which is sort of beyond the scope of this discussion, can be invalid. That in turn, if you don't deal with it on the front end, can create issues relative to additional insured status. That is an obligation that also exists under the contract, where you as the sub are required to provide additional insured status for the contractor under your insurance coverage. If the provision that is in the contract is void or unenforceable, and then you attempt to mistakenly include that type of indemnification under what's called a contractual liability coverage under your insurance, that also creates confusion and can become problematic. So it's important to deal with it on the front end. So just to talk briefly about sort of the interplay, you might say, well, what is exactly the correlation between insurance and indemnification? Well, generally, under an insurance contract, an insurer will not provide coverage for liability that you assume via contract. So you can't get insurance for breaching a contract, generally. One of the key exceptions under your contractual or comprehensive general liability policy is called contractual liability coverage as it pertains to indemnification. So if you contractually agree to indemnify a third party, your insurer is obligated to provide coverage for claims that arise pursuant to that indemnification obligation. If you did not contractually agree to indemnify, in most cases, or I don't want to say most, but in many cases, then the insurer, your insurer, will take the position that, excuse me, there's no contractual liability here that is an exception to the general rule that says no coverage. There's no contract that requires this indemnification. So by including this indemnification provision in the contract, that triggers the insurance coverage that applies to respond to those indemnification claims that the contractor makes against you as the sub. So I think you're starting to see the clear interplay between the two. So let's talk briefly about what I alluded to earlier, this distinction between additional insured status that comes from what's called an additional insured endorsement versus what many of you may be familiar with, which is called a certificate of insurance. Certificate of insurance, some of you may see that it says ACORD at the top, ACORD, okay? That is a certificate that identifies the certificate holder, but it is not the same as a legally binding act or document that gives the additional insured status under your policy. And the certificates of insurance are often issued by brokers, and they're good in the sense that they can be done quickly. Oftentimes, this is a fire drill, right? You're checking off boxes. Where's the proof that I've been added as an additional insured? Here's the certificate of insurance. I got it from my broker. And it's not enough. It's not enough. It's not enough because if you didn't do it right, the contractor could have a claim against you as the sub for breach of contract. You were contractually obligated to add the additional insured onto your policy. If there was a breakdown in some way and you didn't do it, it's a breach of contract, number one. Worse, the contractor sues, files a claim against you, the sub, and because of something that happened, you didn't properly have this endorsement issued that gives the additional insured that status under your policy. Now what? It doesn't make the indemnification claim go away. It's still there. But now you're on the hook for it. And you potentially now have no coverage for what can be a life-ending claim that for indemnification that the contractor makes against you, the sub. So it's clear that you have to be careful, distinguish between certificates of insurance and additional insured endorsements that will clearly indicate that the additional insured, that the contractor has been named as an additional insured under your policy.
Yuri, 1 second. There's a question from Melissa Williamson. She wants to know if we as a sub have the certificate of insurance sent to the GC and it does not have the proper coverage outlined, who's responsible for the proper coverage not being in the insurance policy?
That's a great question. So unfortunately, the buck stops with you because it was your contractual response, you as the sub, it was your contractual responsibility. Now, you may have potential claims against your broker who screwed up in some way and didn't properly do that which you asked the broker to do. But who wants to deal with that? You are now then on the hook. You are now facing the potential devastating consequences of having to defend these claims yourself. And now you have to potentially go after the broker for the broker's errors and omissions and not having properly had this additional insured endorsement issued. You don't want that. So it's better for you to do your due diligence, whether it's a paper or a physical binder, have a file. You got to have that. You got to put it as one of the important things on your checklist. You've just got to have it. And one of the other things that should be done periodically is you should verify your coverage. So one of the things that happens sometimes in the event of claims is something called the erosion of limits. Erosion of limits means, for example, you have $1 million in primary coverage and $2 million in umbrella coverage. And you might think, you know what, that's enough to protect me in my own business. And it could very well be. And when I say in your own business, I mean direct claims that are made by third parties against you. You may think that sounds like more than enough coverage. It may be, again, but it may not be as it pertains to indemnification claims that the contractor can make against you as the sub. Think about it. Big construction defect claim. You're a stud or drywall a sub. Bunch of construction defect claims arise out of that trade, out of your work. And the contractor says, out of the total claim, we believe that 5 million of it, you sub are on the hook for it. And then you then realize that maybe the insurance coverage limits that you had in place that you thought would be enough to respond to direct claims against you are not enough to respond to indemnification claims that are essentially indirect claims that the contractor makes against you as the sub. So it's important to periodically check those limits. There's also an argument that to be made by the contractor that if you took on this responsibility to provide additional insured status to the contractor under your policy, and your limits were eroded, that you breached by virtue of that alone. So it's important to review. Do not count on your broker to perform this review for you. You know, the broker doesn't necessarily know all of the stuff going on in your world, all of the claims that are potentially contingent claims. I don't think it's really reasonable for you to assume that your broker should know about all that. They don't know the intricate details about all of your jobs, the potential risk factors associated with those jobs, you know, whether any issues arose during the course of those jobs that have not yet materialized into claims but might in the future. You need to have a handle on that. So I was going to talk more about some of the other what are called proprietary endorsements that insurers try to slide in order to restrict coverage. And some of these are very significant because, again, it could be that you are on the hook and you're required to provide this additional insured coverage to the general. But by virtue of what are called these proprietary endorsements, your insurer has severely limited the coverage that is going to be available. And I'll just give you a few, but there are many, because obviously, think about it, the insurance company's job is to collect your premiums, of course, but then pay out as little as possible. That's just the reality. So they're going to do that in ways that may, on the surface, seem reasonable, but in reality are not, because they don't provide you with the level of coverage that you need with respect to the obligations that you've contractually incurred with respect to the contract. And that's problematic. So some of the endorsements restrict coverage by virtue of speaking to time limits, limits of liability applicable to the additional insured that are restricted by the amount of limits required in the contract. So you're required to maintain a minimum of X coverage, okay? But that conflicts potentially with the indemnification obligation. The insurer might take the position by virtue of this endorsement that its liability is limited because of the fact that you agreed to only maintain X dollars in limits in the contract. Other things, other examples are notice of occurrence, where the insurer will only cover claims where notice has been given as soon as practical or practicable. What about claims where they don't raise their head for months or even years afterward? That could potentially be another means of the carrier declining coverage. So you need to look at those. And you need to get a handle on claims, even if they have not formally been made against you, because that can have a potentially make or break effect on the availability of coverage. And then the other one, this term that you've heard us use here today is the tender. The tender is the process by which a claim is submitted by the insured, whether it be you or the additional insured, to the carrier. Tender has to be done right. It has to be done timely. There are many, many issues surrounding tender. Oftentimes, you need to be careful about which policy you're tendering under. So you may or may not want to tender under all of your policies when you have different types of policies, because there might be different types of exclusions. You might be in a better position under one policy over another because the likelihood of the carrier having to take on the defense obligation, which is much broader than the ultimate coverage obligation, that again, that could be a make or break for you. So if one of your policies has potentially broader defense coverage, you may want to tender under that policy rather than the other policy initially. Other limitations speak to negligence versus your work. So, you know, the most insurers will only provide coverage to your negligence other than coverage arising out of your work. So whatever work it is that you performed that was faulty, the carrier is not going to want to pick up the tab for that. But if your work caused other damage on the project, that is outside of the confines of the limitation that applies to your work, and that they will provide coverage for. So those nuances in terms of how to describe exactly what's going on and what's at the heart of the claim could make or break the availability of insurance. I think I'm out of time, but the takeaway, it's important. Don't gloss over it. Understand the interplay between indemnification and insurance. Study your insurance. Be careful about relying too heavily on your brokers. And whenever issues arise, think insurance. It should be the first thing that pops into your head, think insurance. If there doesn't end up being coverage, there doesn't end up being coverage. But if you don't think of insurance first, you're potentially missing out on perhaps your greatest way of surviving a disastrous or catastrophic claim by a contract. Thank you.
Great job, Yuri. You know, what happens that I've seen a lot is general counsel to many companies around the United States that we represent together, that you get a letter from the general contractor to the subcontractor, and they say to you, you obligated yourself to protect and defend me against certain items, and if you don't, like a loss or defects or property damage to the building or to other people's work, then you're going to go ahead and be responsible to defend me. I'm asking you to tender this lawsuit or this claim to your insurance carrier. And there's a bunch of different insurance policies, kind of what you just said, you have certain choices. Sometimes you got to think about, what insurance do I have? So we have, you know, maybe you can like summarize, what is the insurance that a subcontractor or GC would typically have that they would then tender the policy to?
So thanks, Hal. So the one that I spent the most time discussing today was what is commonly referred to by the acronym of a CGL policy. So that is either a commercial general liability policy if you're on the insurance side, and if you're on the policyholder side, it's a comprehensive general liability policy. You might say, well, why the difference in the vernacular? Well, because of course, as the policyholder, you want that coverage to be comprehensive. As the insurer, you don't want it to be so comprehensive. So that's what we spent most time here discussing, and that is generally what's called an occurrence-based policy. It's triggered by an occurrence, which is, you know, an hour discussion of itself. But there's also a errors and omissions type policy that might apply. Sometimes a sub's work goes into areas that are more design oriented, for example. So an example might be a stud and drywall sub that also does some exterior cladding work on a building, where, you know, the issue arises as to whether their work complied with shop drawings or something like that, or a mock-up. And so that can potentially trigger a different type of policy. So it needs to be studied when the claim comes in.
I think the point that you raised, which is really good, is that you need to inventory your policies because you're going to forget them in the heat of the battle. Because
Yes.
with today's overload of information, your mind isn't always working, as sharp as it should be all the time, unless you're very lucky and you have a good team around you and you yourself are familiar with this. But it takes years and years and years to kind of get the instinct of what you're talking about. And I'm really glad you brought this subject up and you did a really great job summarizing it. So like you mentioned, like policies that he wrote, well, those design policies or the, I think they're called professional, what do they call professional design or something like that. Mainly they would be, as you said, for somebody that's signing a contract and they do a design build. Okay, then they take that responsibility. Then you've got the word in contracts, design assist versus design build. How far does it go? I was talking to a few of my construction manufacturer clients this week in California. I think I mentioned this case to you, this California council. I mean, your state has California licenses for contractors. My client was an out-of-state manufacturer of window products, and the subcontractor claimed that we were not going to get paid. We're having a battle trying to get paid on the job. We've leaned it, we're litigating it. And he asked in the litigation, he said, hey, I'm suing you because I paid you money and you were a design build party, therefore you're a contractor. You're not just a manufacturer. And I want to take all the money I paid you since you didn't have a license and gorge it out of your pocket and give it back. Now, naturally, as counsel, who was at the beginning of the job, which we were, and we sent out the notices and we filed the liens, we weren't even thinking of this possibility could happen. You got to give these guys credit as a subcontractor for having such imagination. But when we pointed out the terms and conditions to the judge said, even though you're providing shop drawings, you're really not the engineer of record. You're really not the designer. The fact that you did what are called structural calculations in a window frame to make sure that the structure of your product will, in conjunction with the building, be in accordance with code compliance, so it's not falling out in heavy winds and rains and things like that. That doesn't make you a contractor. That makes you a manufacturer that's doing your job and making sure you're engineering your product correctly, not the building. And the judge threw the claim that we were a construction contractor and therefore needed a license, thank God, out the window. Okay, that was there. And the best part about the case was then the judge ruled that he decided this because he used the words design assist in the standard terms and conditions, and that we weren't responsible for, like in Gene's client's case, consequential damages, late deliveries, the terms of sale. So as a lawyer who was always writing this, it was nice to be able to tell the audience that we now have a set of terms that a judge has adopted, and he's already ruling in our favor on the license. I'm guessing, but we don't know, we'll find out, that he'll take those same terms of sale and put that for the benefit of our client. So our trial lawyer actually worked with us, and we strategically were pissed that he would dare claim we were a contractor and steal our money back. But then we said, all right, we're probably going to win this, but let's get our terms of sale adopted here too and convince the judge otherwise. So it kind of backfired on that subcontractor who, it's hard for me to like express myself so professionally, who tried to take my construction manufacturer's, products that he never paid for, and try to take the little money they did pay us back. And, in California, that could happen. You must be aware of that as California counsel, if you don't have a license.
Yeah, so California is one of the states that is probably most draconian on that issue. So it's no surprise that they would try to trigger that to gain an unfair litigation outcome, frankly. But, those types of provisions exist in other states as well, obviously. So very important when you're a, even a third tier provider providing work on a project where you're crossing state lines thinking, well, I'm not really doing work on the project. I'm sort of just a vendor, just providing a product as opposed to a service. Those lines are often blurred.
Right. Yeah. And there's people that are in our legal network that specialize in representing these issues in contractor licenses, as you likely are doing too. So one of the things I think is important, speaking of California, let me share my screen with the audience for 1 second if I can. Is a case, let's see, that came down called United Riggers versus Coast Iron Steel. And Yuri's talking a little bit about this today. So what I liked about this case, it started in Los Angeles, and it ended up in the Supreme Court of California. And I really like the perception of the Supreme Court of California. I think the audience would be interested. The judges say, this is the reported case, so it's very interesting. This case is about construction, physical and statutory. Spurred by late payment problems in the construction industry, the legislature established payment deadlines and imposed penalties on owners who delay payments to their direct contractors, and penalties on direct contractors who delay paying their subcontractors. But these deadlines include an exception relevant to this, that direct contractors can withhold monies from subs in circumstances where a dispute has arisen. And what we must decide is whether this exception allows withholding when there is any dispute between the party, or only when there's a dispute directly relevant to the specific payment that would otherwise be due. So I'm going to be sending some information out to the audience today afterwards, and we'll be taking some of the slides and information from our panelists and circulating that in the next few days. I'll send a copy of this case. I'm not going to tell you how the Supreme Court ruled. I want you to read the case. It's very exciting. It's pretty short, and I think you'll enjoy it. And, you know, what is the Supreme Court of California going to say? Can somebody withhold all your money or just the amount of money that's in dispute? I think it's 150% of the amount. So we'll see exactly how the case is decided. So let's pretend we argued it today and we're waiting for the court to make a ruling, and you'll get the surprise of seeing how the ruling will come out. This has been a really great audience, great questions people ask, and I want everybody to know National Lien and Bond has one passion. We work together, 50 lawyers in 50 states, notice services all across the country, trade associations, credit groups, and people like you to do one thing. We all together want to get paid when we do our work. And I think that's something that's really great for you as suppliers and subs and GCs to do. And it's great for a GC to pay a sub, and it's good for a sub to pay a supplier, and everyone to get along, you know, after, you know, they shake out whatever the problems are. Recently, you know, we've been pushing non-litigation but problem solving, and I can say that so far in the month of September, we've been able to solve a bunch of cases where I called up two people today. One Gene and I are working on in Bowling Green, Kentucky, and I asked the general contractors project manager, "Hi, I'm not here to file a suit. I'm here to solve a problem." And then he complimented Gene's lien. He acknowledged that the lien on funds was good, very strong. He realizes they have payment bond claims as a GC, and the subcontractor also has payment bond claims. So the GC, through indemnity, said, "Hey, will you negotiate with the subcontractor?" I said, as I said, I'm here to talk and listen. Let him call up Gene or myself, and we'll solve it, or call our client and we'll talk. Then we had another case recently, actually, that coincidentally Yuri and I are working on. We don't know what's going to happen with that one. And Yuri's client's having a little problem. We're trying to help out a little bit, where they need the GC who's been paid 2 years ago to pay attention. Like, when are we getting paid? So we called up the public job, and after like going round and round with COVID, can't get a hold of somebody. Somebody called me back today and said, are you the attorney or the client? I said, I'm the attorney for the client, a subcontractor that built your facility, and 2 years was in construction late. You know that. He goes, who's your client? So I told him. He goes, well, I can't speak with you because I'm not a lawyer. You can speak to our lawyer, but better yet, let me have either the lawyer call you or have the general contractor call your client. I go, good. Why don't you do both? And let's see what happens. So now there was no dialogue. We'll keep our fingers crossed, okay, that we'll get something done. Who knows? But in the meantime, I want to thank everybody for coming. I don't see any more questions and answers. So, ladies and gentlemen, we enjoyed having you. And mechanicslien.com, that's sponsored by National Lien and Bond since 1985, is a great organization We've studied the laws from the first Mechanic Lien Act from 1791, 230 years ago. We're going to be celebrating that in December. Stay tuned, and you'll hear about more information this year on your lien rights in your states and information. And you'll be getting an invite to participate in sharing information, particularly in this case, subcontract provisions that are going to help you avoid one-sided contracts and get you paid. So have a nice day, everybody, and look forward to get paid on your work. Thank you.